You're only as good a lawyer as the variety of matters that you've done. So a lot of law you only learn when you're doing a particular matter. You are able to go in depth into that law.
Hello and welcome back to another engaging and amazing episode of the Super Law YouTube channel. Today we are joined by Shloka Narayanan. Ma'am is an advocate and record at the Supreme Court of India and an off counsel at Povaya and Co. With extensive experience in technology law, data protection, and complex commercial litigation, she has represented leading global technology and social media companies in landmark cases across India. Ma'am also serves as a guest faculty at the National Law School of India, University. Her work reflects a deep commitment to evolving intersection of law, technology, and policy. Thank you for being with us today, ma'am. I'm Anshi. I work as a senior associate with the Super Lawyer team. At Super Lawyer, we showcase inspiring journeys of legal professionals offering valuable insights that greatly motivate and benefit our viewers, which are young lawyers and the legal community at large. Thank you so much, and I request the women to now please continue with the conversation.
Hello and welcome, Shloka, and thank you so much for giving us time. And thanks, Anshi, for the introduction. I really do hope that you will enjoy the conversation because I am pretty sure that we are going to enjoy it too much because you are newly minted AOR and you have practiced in technology and law, which is kind of our favorite subject right now. So I hope you'll enjoy it, and thanks once again for being here.
Of course.
So let me start with the very, very obvious question that you being the AOR now, the decade of experience that you carry with yourself, it has a lot of different genre to it, but your foundation has been very, very specific. Like you have always stuck with technology and law. So how did you choose this for yourself and how have you built your practice around it?
Actually, I'd say it's just a series of fortunate events. I don't think when I was in law school, I thought that I'll be a technology lawyer. I didn't know there was something called technology law as a law student. But I think what happened is that the choices that I made because of several other reasons, sometimes personal, sometimes on a whim, sort of led me down this path. And I have no regrets, of course. So in 2020, when I joined Povaya and Co. as an associate, is when I really started to explore technology law as a subject. And that's when I knew that there's this whole field and there are people who specialize and do this kind of work. I was actually hired by the law firm to do something quite different. I was hired to do regulatory law, but I did that for a couple of months and I didn't enjoy it too much. The firm didn't enjoy me doing that too much, I think. So just by chance, I did a few technology law matters and it came more easily to me. It was also around the time when COVID struck. So regular litigation had completely reduced and we were getting more and more advisory work, especially because in 2021 we had the new IT rules which came up and all of that. So I would say it's just a mix of various combination of factors which has led me to where I am. And it wasn't a conscious decision. I feel like students who come out of law school these days, they know what they want to do. They come for internships and they say, I want to do competition law or I want to do technology law. But I had no such aims. I wanted to litigate is all I knew. And then just the series of decisions I made have led me now to becoming a technology lawyer.
So, how has this practice of yours, which you did not consciously choose, to go for advocate on record examination as well, which in itself is one of the very tough examinations? How did you move from this to being into Supreme Court and working as an AOR? And how has this turned out because you recently have qualified for it? What kind of new experience you are having with the qualification of being an AOR?
So, in my first 3 years of practice, I was doing a lot of general civil and commercial litigation. And even when I was doing technology law work, I tried to keep in touch with that because that is also exciting in its own way. There's a lot of variety in civil law, there's a lot of learning in civil and commercial law, I feel. So, I sort of did a 50-50 or 60-40 of civil law as well. And then when I moved to Delhi, I saw a lot of AORs around me. And I started to believe that somehow qualifying for this examination or writing the examination will allow me to do a variety of work outside of the tech law practice that I want to continue to do. Because at the appellate level, at the Supreme Court level, almost all AORs don't pick and choose any specialization. Every AOR does criminal matters also, civil matters also. And that gives you a very broad range of work that you can do. So, yes, I am newly minted. So, in that sense, it's very exciting at this stage to be able to appear every day in the Supreme Court. And I always feel like trial work is way more difficult than working at the Supreme Court, because here you're at the final stage and you're just picking faults with what all the other lawyers at the lower courts didn't do well. But, that's the tough part. And at the Supreme Court, you have the benefit of hindsight. So you're able to just come to the point, and that 2 minutes that you get with the judge at an SLP admission stage, you have to convince someone. So all of that is very exciting. But I want to continue to keep doing civil work at the district court, at the high court, etc., because I think that's the tougher part of being a lawyer.
So, what would you suggest the young professionals who enter, like you said, they come with a decisive mind that we want to do this or this particular field we want to choose. But sometimes, even those people who have come with that made up mind, they change their path. So, what would you suggest how to keep up with all of this competition that is going around and work for better path to choose? Because obviously, it's not easy, as you said, that in Supreme Court you pick others' faults, what they could not do. But at the district court level and other courts, you have an opportunity of litigating in a different manner. So, what would you suggest those young professionals and how they can be cautious enough to pick and choose their careers?
I mean, I still consider myself a bit young, so it's a young giving advice to the young, let's say it like that. But no, jokes apart, I think that everybody should do a little bit of trial court and high court work before coming to the Supreme Court. And even if you choose a niche area like competition law, you want to practice in the TD SAT, I think 6 months to 1 year, everybody must get the trial court experience, whether civil or criminal, because that holds you in good stead, I think, for the rest of your career. And the great thing about litigation and the law is that no decision is final. Today, I've decided I've done technology law for so many years, but I can tomorrow decide I want to switch to criminal trial. Yeah, of course, I'll have to start from scratch, but it's not an irreversible decision. So I think you should always be open to sort of making that switch and also playing to your own strengths. Like, for example, I said I was hired for regulatory law, but I'm not good at it. So you also have to be honest with yourself, and you might want to do competition law, but that might be more difficult for you to do, and you might be better at, say, securities law or something that comes more naturally to you. So my general advice to anybody who asks me how to pick is not to be too rigid about what you want to do. And first 1 to 3 years of practice, try to do as many matters as you can in different fields. Like my former senior used to tell me that you're only as good a lawyer as the variety of matters that you've done. So a lot of law you only learn when you're doing a particular matter. You are able to go in depth into that law. So yeah, I would say trial court experience is invaluable, and always be ready to change your mind and not be rigid on what one field you want to choose.
Along with technology law, you also extensively work in privacy laws. How do you find this difference between different jurisdictions when you are working and the kind of developments that keep on happening? How do you take on that particular challenge? And if some case arises, how do you keep yourself abreast with the kind of requirement it has? Because let me give you a small example. Let's say GDPR rules are there, then we have our own data privacy law without being a reality yet, but still we rely on IT Act on different varieties. So how do you make your client or the person who has come to you with a case or the company explain to them how is it happening, why is it happening? Because privacy is kind of a reality now. It was not when maybe that company had started. So how do you work on those kind of policies? Like you said, you work on advisory work as well. So how do you help them nurture their privacy from I would say, scratch?
That's a very good question. And I think a lot of it has to do with just interacting with people and looking at things also from a business perspective in addition to the legal perspective. And that I think is basically the USP of technology or a privacy lawyer. Everybody can read the act and the rules and say this is what it says, right? It's about going in depth into, okay, why is a client providing this service in this manner? Why is their server located in a particular jurisdiction? Why don't they want to change these things about their offerings or their products? And how difficult is it going to be for them to comply with the law? And that you can do mostly by just hearing a client out, hearing different clients out, and keeping an eye on articles that people write. Now there's so much available online, so many newsletters, so much in the newspaper, everything, where you will find that several times clients themselves put out their fears, they put out their real world problems. And reading those things gives you really an insight into how to provide solutions that are both legally acceptable but still commercially make sense. And anytime some new act comes, new law comes, my first instinct is to spend a couple of hours, not read any article about it, not read any criticism about it, but read it for myself. And then I have a group of other lawyers, some non-lawyers, and we just try to brainstorm and discuss what the rules say, how could it be better, what are the good parts about it. So I remember I did it when the IT rules came out. I did it when the DPDP came out. So I think a lot of insight comes from your own just spending time and reading it, and then interacting with a client and finding out what is their business perspective of it.
So to explain to someone, first we have to explain it to yourself. Amazing idea. Actually, I also do the same thing, and that's why I was very curious about understanding that you are a guest faculty also at NLSIU. You teach cyber law. You are an AOR. You are committed to your clients' work as well as the students. You want to teach them and give them the best input from what you read. How do you first of all balance in between these two, and what kind of resources do you look forward to when you are about to take classes, because you really don't know what kind of question will come up? So how do you prepare yourself, and what kind of change or difference have you seen in between the discussions that you may be doing in your bar room, or when you are discussing it with students who are absolutely overqualified when they are doing this NLSIU, cyber law, and other spaces? How do you manage these two?
Actually, that's a really good connect that you made. That's another way. Just interacting with students and their questions help me get a lot more perspective on the daily. That's a really good segue into that. Well, the short answer is that no, most of the time I don't balance it well. There are days when I'll postpone my class at the last minute because some matter is listed for final hearing on a Monday. And there are days when I have to set a question paper for the class. So, I've taken an adjournment from some hearing. So, yeah, the short answer is I don't think there's a good way to balance it. And I try, but I fail a lot. But yes, you're right that especially the program that I teach, it is not meant for lawyers. It is meant for people from all sorts of backgrounds. So that's another way where I have to make sure my content that I teach is accessible to non-lawyers as well. Insofar as material is concerned, I have access to the NLS library, and there's a lot of material there, I dare say, outside India, which is written in a manner that's more accessible to non-lawyers. So I do tend to rely a lot on non-Indian material. But otherwise, also, because a lot of technology law and privacy law, data protection, all of that is in such a nascent stage, most of the classes are more discussion based. Some of the students, I call them students, but some of them work at the ministries or as police officers. So they know much more about this tactically than I do. So their insights are actually invaluable when we're looking at all of the legal questions. And it does help me think about things in a different perspective, especially with a lot of the generative AI things, because I don't have a technical background. I only know the legal side. But a lot of my students will explain it nicely to me. And then I have to sort of apply the legal concepts to it. And tell them how it would pan out or it may pan out, because right now there's no certainty on anything. There's no law. Some courts are, of course, considering it, but there's no certainty.
So again, I'm getting back to your teaching and being a AOR connection. I know this because I also once was a student of NLSIU, and there were so many professionals around me who had much more advanced understanding about these kind of concepts, even before it became a reality for general public. Does it any way help you in a combination of technology and law for you as a practitioner? And does it help you in any manner to work around your cases also? Because there may be a possibility that you can establish a connection between a question that you were asked in a class and the kind of case you may be dealing with, or maybe it comes in future. So, do you find that particular connect, and is it helpful in having those kind of advanced thought process inculcated in our young professionals also? Because probably that is going to be the reality in maybe next decade or so. So, how do you see that particular thing happening currently in India?
Definitely, it does help. Sometimes I remember, for example, in a recent class, one of the students were asking me that how come all the celebrities are going to the Delhi High Court to get injunctive orders for personality rights? And that's a very good point, right? Because most of them are based out of Bombay, or they're definitely not based out of Delhi. So I thought that that was a very good question coming from a non-lawyer. And then a few days later, I saw that one of the Delhi High Court judges has asked the same question. He says, how does the Delhi High Court have territorial jurisdiction to decide this dispute? Right. So I'm not directly involved in that litigation, but definitely there are connects between the teaching part and the practical part, especially in this field, I would say, because it's so evolving. And sometimes the litigant who is coming to court is closely related to some sort of student, not in the direct sense, but at the end of the day, a litigant is a member of the general public who is interested in technology and privacy and data protection and all of that. So it is very closely connected. And I think justice is also becoming more accessible now. After VC hearings, people are able to log in and watch what exactly happens in a court. So they are interested in getting courts' final views on all of these things, like personality rights and data protection and large companies using data, whether that amounts to consideration in a contract and all of that. So I think it's very closely related, and it's only going to become more entwined as we go. So it is a very good idea for the younger professionals to start closely trying to relate what goes on in the courts really and such academic fora, like, for example, a PG diploma in technology law.
I do hope brain rights or neuro rights also becomes reality anytime sooner, because that's kind of a little touchy subject for me. Keeping all that in mind, you have also represented major social media companies as well during litigation across India in form of global blocking and interpretation of IT Act. How do you explain it to them that this kind of space, especially the technology space, the kind of evolution happening, the kind of disruption happening, they have to become well equipped with their understanding of not only privacy and data laws, but also to understand how it is going to impact the society? Because that also has become a very important issue nowadays, also involving environment. So how do you see or explain it to them in easier language which they understand?
So I've noticed that with the large technology companies, the companies actually already know these things. You don't have to explain it to them. They are very, very competent in terms of not just their legal teams, but in general, all the social media companies, I think, have representatives who are very aware of the power of social media, but also the downside of it. So I think that they know that they have to toe a very fine balance. But the fact that they have operations in so many countries, they bring in learnings from various jurisdictions to India, and of course, vice versa, carry their experiences from India elsewhere. But as a general comment, I think what we have to basically explain to them is Indian litigation. Everything else they can explain to us. So the challenge sometimes is there because Indian litigation is very, very different, I think, from litigating in Europe or litigating in the US or even Singapore for that matter, in terms of variability, in terms of timelines, costs, unpredictability, all of that. So they'll really look to you as a counsel to give you inputs on those aspects. And the fact that there is no codified law in many of these aspects, for example, global blocking or right to be forgotten, so many of the hot issues in technology law today, it sort of works both ways. It also helps the social media companies to put forth their view and get the law molded in such a way that it works for them as much as it works for a consumer. But it also gives a lot of play in the joints and a lot of uncertainty on what could happen tomorrow. Tomorrow, if suddenly Indian law resolves in favor of the fact that there will be a right to be forgotten, then how do you suddenly start complying with these orders? It's not that you have to change your engineering throughout the world, you have to change it for one particular jurisdiction. So cost of compliance increases. So those kind of things are what you really have to explain to them. Otherwise, they know more than me in many circumstances.
They know in terms of doing business, I would say, not exactly in terms of law, as you rightly said. But yeah, they also try and understand that comparison, whether you can explain that particular comparison or not. So, doing all this with your decade of experience, you being a young lawyer, what kind of case was, without taking any names, if you can remember any case which has been very challenging, where you had to strategize, and what kind of change have you seen along with these kind of cases over these many years? Because Indian litigation related to technology law also has changed leaps and bounds. So, how do you see that change happening for you and for your clients? And obviously, the most challenging case and kind of strategy that you built.
The most challenging case, I mean, it's tough to name one. I feel like a lot, but there is one client that I was representing quite regularly at the firm. And all of those clients' cases were challenging in the sense that as a social media company, you generally take a very neutral position. But this particular client was happy to take a more hard stance. And in all of that, there were a few big ticket litigations for them in India. And I advised on most of them, or I was representing them on most of them. Those were really challenging for many reasons. One is that, like I said, you have to explain Indian litigation to them in a language that they will understand.
But you have done that successfully and done and dusted with, and you are moving forward with new ideas and new concepts that are coming every day. As innovation is happening every second of the hour, every day. We are towards the end of this particular conversation. I really am fascinated to ask right now about how do you balance your physical and mental health? Because you are dealing with some very big social media giants. You are working in a very competitive environment and you have been dealing it for now well over 10 years. So how do you do it for yourself? How do you keep yourself calm, understanding, and being able to cope with this physically as well?
It's very tough. I mean, there's no other answer to it because I've had phases where I've really struggled with being able to be in good mental and physical health, especially because I think the biggest challenge is time. Time is not in your control when you're litigating. And especially if your clients are not in India, you have to make time for calls at odd hours and all of that. So the first thing you will sacrifice is going to the gym or going for a walk or whatever it is, dance class, whatever it is that anybody does for fitness is, I think, what takes a hit at first. Same way with food habits. If you spend long hours in the office, you tend to order food, that kind of thing. But I think at some point, maybe 2 or 3 years ago, I sort of sat with myself and said that this is not going to work. There's no point if I'm burned out at 32 or 33, because like someone told me, litigation is not a sprint, it's a marathon. And so if you have to work till you're 70 and 80, you have to take care of yourself. So now I'm trying, in the last 2 years, of course, things have tremendously improved, because also I think you have to decide to prioritize it. And if you mentally decide that, no, I will ensure that I have this much time in a day to work out and this much time to ensure that I spend with my family, it is possible. There will be bad weeks, there will be bad days, but I think you just have to be strict with yourself. And the biggest, I think, challenge is to be able to say no, to be able to tell a client, no, I can't do your matter because whatever, I'm getting married, or I have, this commitment or that commitment, because otherwise there's no end to it. And it is very competitive. If you are not willing to do it, there's somebody else willing to do it and do it better than you, and maybe at a more affordable price than you. But that is the cost at which your mental and physical health comes. So I think after you're 25 or 26, you have to prioritize it and say, no, that this is also important if you have to survive till you're 65 or 70. But it's tough.
Wow, so true. And thank you for being very, very clear and candid about accepting that it's tough. It's not easy to even say that it is tough. Thanks, Shloka, for being so easy and crystal clear about the understandings, and absolutely fascinating job that you're doing. And once again, congratulations on being new AOR. I do hope and wish that you reach new heights. And our country also sees a new technology lawyer who will be dictating her own terms. Amazing. Thank you so much.
Thank you so much. Thank you.